Hi, everyone. Welcome back to PI Northeast The Break. My name is Clare Irvine. I'm Government Affairs Counsel here at PIA. And I'm joined by our Director of Government and Industry Affairs, Brad Lachut, to discuss New York's recent legislation that was signed into law by our new governor, Governor Kathy Hochul, that prohibits insurance carriers from using dog breed effectively as an underwriting factor. So I'm going to turn it over to Brad to discuss this legislation forward and what it means for insurance agents and insurance policies.
Great. Thank you, Claire. And thank you, everybody, for joining us. As Claire mentioned, I'm going to be talking about this new New York law regarding dog breed and underwriting. So I'm going to talk about what the law is and then get over into the real world implications. So the law, what is it? It states, excuse me, that insurance carriers are prohibited from taking an adverse action against a policyholder. Adverse action is my term. The legislation actually spells out, I'll get that in a second. But basically, a carrier cannot take an adverse action against a policyholder or a potential policyholder. So somebody walking in through the door can't be discriminated against either. Based upon the harboring or owning of any dog of a specific breed or mixture of breeds. The adverse actions include refusal to issue a policy, refusal to renew a policy, cancellation of a policy, and then increased premium or rate. So a couple things to take apart in this definition. One is the prohibition applies to those who not only own dogs, but also those who are quote unquote harboring dogs. So somebody that is fostering animals, a rescue, that sort of thing, they would fall under this as well. A carrier could not take any of the adverse actions that are listed on the screen against those individuals who are simply harboring dogs, not just owning them. And again, this is based on breed or a mixture of breeds, and also it states that it's solely based on that. And I'll get into what that might mean a little bit more later when we talk about the real world implications. So the law in a nutshell is this. Insurance carriers cannot take an adverse action based on the breed of dog. Now, like any law, there are exceptions, of course. This law is no different. It has what it is termed as the dangerous dog exemption, which is really not much of an exemption at all, which I'll talk about in a second. So under this exemption, carriers are permitted to take an adverse action against a policyholder if a dog is found to be a dangerous dog, quote unquote, under New York State agricultural and markets law. So why this isn't much of an exception? Well, first of all, the legislation states that carriers cannot take an adverse action based on the breed of dog. This exemption doesn't talk about breed of dog, it's talking about specific dog action. So it technically would be exempt anyways without this blatant spelling out, but at least it's there and we know for sure that carriers can rate on dangerous dog. Now, the other issue with the exemption is that the process for designating a dog as dangerous is a fairly complex one. It has to go, you go through local courts and judges making determinations and weighing evidence and all of that sort of stuff. So it's not a quick and easy process. So the amount of times that it will actually happen are probably not great. And again, not a real exemption to begin with. So that's what we have here, the dangerous dog exemption 2, what the underlying rule is. Again, carriers can't take an adverse action. So now, what are the real world implications going to be? Well, this legislation is effective 90 days after it was signed into law. Signed into law October 30th, so by my math, if that's right, fingers crossed it is, it's going to apply for all policies that are issued, renewed, modified, altered, or amended on or after January 28th of 2022. Now, we can figure out what issued, renewed means, right? What about modified, altered, or amended? What does that actually mean? Thankfully, we have some recent clarification on this from the DFS, a law that went into effect last year regarding coverage for limousines had very similar language. And what the DFS said in that instance was that purely administrative changes to a policy, correction of a name, for example, typographical errors, that sort of thing, would not be considered modified or altered. It has to be a significant change to the policy that would lead to premium changing or the risk changing on the policy, not just a simple administrative change. So be aware that, if somebody's adding a risk to a policy, they got a new trampoline or got a new dog, then that could be something that triggers this, this new requirement. But something again, like changing somebody's name so that it's an I instead of an A, not likely to trigger it, or not going to trigger it. So past or once we hit January 28th, what can we expect? Likely rate increases, right? So as I mentioned, the law only prohibits adverse action based solely on breed of dog. Carriers could consider other factors, including the presence of a dog in the first place. That is a permissible rating factor under this legislation. Just can't take into account of the breed of that dog. So presumably carriers will look at all those individuals who have a dog and then increase their rates to make sure that they're meeting the risk of the most dangerous dogs, I guess, out there. In addition, other characteristics of dogs could be used into the dog. So for example, size could be a characteristic that a carrier might want to use in underwriting. Now, the challenge there is that carriers are going to be required to justify those rate increases or whatever they're going to do to DFS. That'll be a process. It takes time to build that information. And you also have to have the DFS go along with it. Going along with that, as I mentioned, the law says solely on breed of dog. So if you combine the breed of dog with another characteristic, that wouldn't be solely anymore. Technically, it's an end around the law. Now, I don't know if DFS would appreciate that and approve that sort of thing, but I think we'll definitely see the rate increases. We'll probably see carriers try to get creative, and we'll see how creative the regulators let them get. And a final just real world implication is there's going to be changes to insurance application. We've already been talking to Accord. They are likely going to add a question to the application that includes something about the dangerous dog exemption that I talked about earlier. So we'll see some real world changes in applications to account for this law. So with that, as always, if anybody has any questions on this, you can reach out to Claire or myself or the Resource Center. There's additional links shared in this video if you want more information on this law. With that, I'll turn it over to Claire for any questions you might have for me.
Yeah, just what the laws don't come really out of nowhere. So I was wondering what did PI do or not do during the legislative process regarding this bill?
Yeah, it's a great question. So bills don't come out of nowhere. They get pushed. So PIA, along with most of the insurance industry, was united on this and pushing against it. For the reasons I basically just stated in that last slide with increasing rates. We didn't think it was a great consumer protection that rates were going to increase for everybody based on this. And I think you're going to see that bear out to be true. What can you do?
Yeah, what can you do other than on January 28th having the freedom to go to a humane society or dog shelter and adopt any dog you want? That's true. They'll all be the same increase to your homeowner's premium.
Well said. Spay or neuter your pet, right?
Okay, well, that's all the questions I have. Thanks everyone for joining us about this bill. Well, it's similar to some of these issues that are brand new. We'll provide more information as we get it, including how it starts, any information we see on how it affects the industry policies.
Thanks, everybody.